This is the first one of our webinars that we're going to be hosting monthly. They're on dispute resolution topics or issues which we frequently see in our office. And today we have IDEA discipline, which is the discipline zones, to explain what happens and what needs to happen with discipline. We're so excited to have Lenore Knudtson with us today. Lenore does a lot of training nationally for state departments, and she trains our dispute resolution programs. We attend webinars, which she puts on with TACE, which is a technical assistance center at the University of Utah, quarterly. And she presents on due process hearing issues, on IEP facilitation, as well as mediation. Lenore's career began as a school psychologist, working with school teams, parents, and children. And this portion of her career, like many of us, ignited a passion for special education and improving the lives of children and adults with disabilities. She earned her law degree with honors, and after law school, Ms. Knudtson began her career as a special education attorney, focusing on IDEA professional development and technical assistance. She works with states and school districts across the nation, and her opportunities for career enjoyment far exceeded her expectations. Her career has culminated in a rich blend of issues focusing on children, from education to juvenile justice, all forms of dispute resolution, and building compliance-driven systems. So welcome, Lenore. We're so happy to have you with us to share your topic. Thank you.
Well, thank you, first and foremost, for the invitation and the opportunity to be with all of you. IDEA discipline is one of my favorite topics, so I especially appreciate this chance to present the topic to you, along with the materials that were posted in the chat box and I believe made available prior to today. There's a one-page handout, and that one-page handout will be used throughout today's presentation. I call it the discipline zones. And it's a handout that is available to all of you. You can keep it on your desk, you can carry it with you, you can save it to your desktop. It should be in the hands really of every person who is responsible for IDEA discipline at the school level. How did it come about? Well, I'm a visual learner, and as I distilled down these very complex topics in IDEA to more manageable, consumable pieces of information, it occurred to me that it had to be visual. It's such a complex topic. So that's what I set out to do when I created discipline zones. And it was a few years ago. I've refined it over the years. I wish that I had the opportunity to provide you with an updated discipline zones based on a reauthorization, but we aren't there yet. I'm not sure if we ever will be during the course of my career, but we are, so everything in discipline zones continues to be true today. I do update it periodically to just keep pace with case law as it comes out, to give you the most recent and refined interpretations. So with that said, we're going to move through the slides today. I do want to encourage questions, but as Rob noted, those will be placed in the Q&A box. And then my goal is to leave a few minutes at the end to be able to field some of those questions. Again, there's a question in the Q&A right now that deals with where do you find the handouts. Rob had posted those in the chat earlier today. So here we go. I think Joanne's introduction was, it was a great summary of my life to date. I did start as a school psychologist. I've been involved with students with disabilities my entire adult life. And more importantly, I think being a lifelong learner. I continue to study special education law on a daily basis, and I do a lot of presenting around the country. Every single time I present, I get to learn something new from all of you. So today, I encourage you to be that lifelong learner, to lean in, to make sure that we are all working together to improve outcomes for students with disabilities. So again, we're here to talk about discipline zones, and this is a must for every person involved in the discipline of special education students. When I have presented this topic, I invariably get one threshold question Typically, it's from regular educators, not special educators. But as we move through the zones today, I'll get the question of, what do you mean we can't discipline special education students? Not true. This is not intended to be a prohibition of discipline for special education students. It is intended to be a regulation of the, it regulates the imposition of discipline on special education students, not a prohibition, it's a regulation. So with that in mind, we're going to move through different topics here. This is the picture of discipline zones. Each section has additional responsibilities for the school district. These happen in real time. These happen pretty quickly as well. So you need to make sure that you're familiar with this before you need it. After you need it, you're typically not going to have enough time to be able to, okay, where's it at? What's my next step? What am I free to do? So get yourself familiar with discipline of special education students before you actually need to do it, right? So the first thing I want to point out is that this scenario that you see on the screen with FAPE-free zone, the analysis zone, change of placement, these exact zones may not apply when drugs, weapons, or serious bodily injury are involved. We're going to round out our conversation today with some pointers about drugs, weapons, and serious bodily injury. So what I'm talking about for the most part today is going to pertain to the most common forms of special education discipline. And those are disciplinary removals for a violation of a code of conduct. So as you see this, I want you to notice the colors. The FAPE-free zone, as we talk about it, is always going to be in green, and it's the first 10 days. And then the analysis zone is in yellow. It's kind of the cautionary zone where you have to start analyzing and providing services. And the answer to your analysis is always dichotomous. Yes, it's a change of placement, or no, it's not. And then we'll go through the additional responsibilities that you have based on whether it's a change of placement. But first of all, some threshold matters. What are we counting? Right? We are counting a disciplinary removal for any violation of a code of conduct. Any disciplinary removal for any violation of a code of conduct. I've been in special education a long time, and I've seen special education discipline evolve. I've also seen some really creative names attached to the removal of students with disabilities and the places that they may go, whether it's the reflection room or the quiet room or the white room. We are talking about any disciplinary removal for any violation of code of conduct. Removal from what? Removal from a student's placement, where they're typically educated. The bundle of services that gets delivered to provide that student FAPE is considered their placement. So any disciplinary removal for any violation of a code of conduct. Again, what is a disciplinary removal? Any instance in which a student is removed from his or her placement for disciplinary purposes. And then you'll see the language in there about behavior that is violating a code of conduct. It might be classroom rules, it might be school rules, it might be discipline rules or district's discipline code. But if the removal is in response to a violation of a code of conduct, that is a disciplinary removal. That's what we're talking about today. If a student is going home ill, that's not what we're talking about. If a student is leaving school to go to a dentist appointment or something else, that's not what we're talking about. We're talking about there's some behavior involved that violates a code of conduct, and there's a reaction from the school system. Right? Keep in mind, and this is very important, discipline must not be used as a means of disconnecting a child with a disability from education. So when you think about, particularly at the younger grades, students that may be sent to the office over and over again, we're going to talk about that in some more detail. But ask this threshold question, are we disconnecting this child from their education? If the answer is yes, a huge red flag should go up for you, a huge red flag. Again, doesn't mean we can't discipline students with disabilities, but it does mean we have to do it according to the regulations to make sure that we are protecting their procedural safeguards. There's been a lot of, I would say, chatter about shortened school day, both in the federal court system right now in one of our states that I work regularly with, there is a major lawsuit going on, a class action lawsuit about shortened school days for students with disabilities. This is kind of a long established premise, but this is something that schools at times get a little creative about. If they don't call it discipline, is it really still discipline? And the answer is yes. If you are reacting to a violation of a code of conduct. Code of conduct violations include all sorts of things that might be disciplining a student for injuring someone else, for not paying attention. I've seen that for students who don't turn in assignments, for talking out of turn, for using the F-bomb, any number of things student discipline may apply. And if that results in a shortened school day to address the problematic behavior, that is a disciplinary removal. And it is subject to IDEA's discipline procedures. This is out of Letter to Mason, which is a reported OSEP letter. OSEP is the Office of Special Education Programs in the United States Department of Education, and they issue regular guidance to us in the form of letters. Sometimes they'll be dear colleague letters, if they're just broad letters to the field. Other times there'll be letters in response to a question that's been submitted to them. So in this case, Mason, whoever that is, submitted a question and OSEP responded with this letter. This is guidance for us in the field. So I want to give you just a few more examples of things that may disconnect students from their education and be disciplinary removals. So for instance, moving a desk or a chair into the hallway and having a student sit there, even if they're supposed to be working independently, would be a disciplinary removal if it happens for a violation of a code of conduct. Okay. I have reviewed thousands of IEPs over the course of my career, thousands of them. I have never seen an IEP that says that the student is going to be educated in the hallway. And so that is not part of the student's placement. Moving a desk or a chair into the hallway happens because that teacher is really at the end of his or her proverbial rope with the student, and they need to have the student removed so that they're not disrupting the classroom anymore. Again, that's regulated behavior. It's not prohibited, it's regulated. Sending a student to the office for periods of time, because we all know that the secretary is responsible for these students. They are not in a learning environment at all at that point. So that could very well be a disciplinary removal. Suspension is the easy one. We know what that is. It's defined. Sending a student home for the day, if it's as a result of a disciplinary violation, a code of conduct violation, that is a removal and it must be counted. Placing any condition on a student's return after a disciplinary removal. For instance, I see things like can't come back till you have a safety assessment, can't come back till you have a psychological evaluation, or anything like that. That extends the disciplinary removal because you've placed a condition on the student's return. Any removal by any name for a violation of a code of conduct, that's a disciplinary removal. What do you need to do with them? You have to count them. In order to know how to count them, the school needs to understand what school day means. It is a defined term in the regulations, so we're not free to vary from this term. The federal regulations have not given us the authority to vary from their definition of school day. There's no latitude reserved here for states. So in 300.11, school day means any day, including a partial day that children are in attendance for instructional purposes. That's really important for us to take in all of those words. It's any day, including a partial day that children are in attendance at school for instructional purposes. Right? School day has the same meaning for all children in school, including children with and without disabilities. That's hugely important in our understanding of what is a school day. So if you are taking attendance in certain fashion to be able to determine, typically for finance purposes, how many students you have in attendance on any given day, how is that attendance taken? Because that will give you some insight into how you need to count partial days as well. How do you count this? Any school day in whole or in part that a student is removed must be counted. Part day is counted as part day in the same way you would count an absence for a non-disabled student. So, for example, typically at the elementary level, attendance is taken twice per day, AM and PM. If a student is removed in the afternoon, then they would be gone for the PM session. Okay. At the high school level, attendance is typically taken every hour. So it could be that the removal is counted hour for hour. Just keep in mind that when I speak about the law, I'm not speaking in absolutes. Go back and check. How are you counting absences in your school buildings? How are you doing that in your state? Is there any guidance at the state level that tells you how to count these? The one thing that is certain is that you must count a part day. You don't get a pass on it because you've removed the student for part day only. And the regulations, because of that very explicit language of a school day is the same thing for students with and without disabilities, it gives us some insight into how to count, right? Just make sure that you count. When does the count start? At the beginning of every single school year. Why is that important? Because it continues, and you're going to keep counting all of the disciplinary removals for each student through the remainder of the school year. And then what do you do the next year? You start your count anew, right? So it's not cumulative over the course of the student's career. The count starts at the first day of school in each school year. Right? So if you have summer sessions for students, you may need to count those days as well. But at the end of that session, when students matriculate to the next grade, the first day of school of first grade or third grade or 10th grade, that's when your count starts anew. We're going to go through some examples here, and I want you to think about these. You can use some of the Zoom features if you're comfortable with them, giving me a thumbs up or a thumbs down, or you can also put some answers or comments in the Q&A section. But this is some examples, real life examples, by the way, of disciplinary removals, but they're removals. And I want you to answer the question, at least think about it. Is this a disciplinary removal or not? Does it need to be counted or not? Right? So this is a student who has his desk placed in the hall for an afternoon after repeatedly interrupting the teacher and classmates. This is one afternoon for interrupting the teacher and classmates. In order to be able to answer this, you'd have to say, is interrupting the teacher and classmates a violation of a code of conduct? Yes, it is. I think it's very typical to have classroom codes of conduct that forbid this kind of conduct. So when a student engages in this, particularly a student with a disability, because that's who we're talking about today, and that student has his desk placed out in the hall, even if it's just one afternoon, you must count it, right? And typically, it really doesn't matter how well-intentioned a teacher might be. There's no learning taking place out in that hallway. This is not the student's placement. And yes, it must be counted. So thank you, Melissa. How do you count it? Well, that's where you're going to need to look at how do you count attendance for students who miss a partial day, all students. My guess is that you would have to count this for an afternoon, that the student would be absent for that afternoon. Okay. What about this one? Student is sent to the office for a conference with the principal each time she receives 3 checks by her name. Right? The proverbial 3-check system. Thumbs up, thumbs down. Do you need to count these as disciplinary removals? Yes, thanks, Rachel. Yes, again. Now, the amount of time may be counted. I mean, if it's a 5-minute conference, you may need to count that time a little bit differently, but you are talking here about taking a child out of their placement and sending them to the principal each time she receives 3 checks by her name for inappropriate behavior. If this happens on a regular and routine basis, this is exactly the kind of disconnection from the learning environment that OSEP wants us to pay attention to. This is exactly the kind of strategy that schools use that can disconnect a child from their learning environment, that should be looked at much more closely if it doesn't improve the behavior. By the way, you know, there are very few, I mean, this may work for a student and may not work for another student. So if a strategy is not working for a student with disability, the team would want to take a critical look at that and say, we can't keep doing something that's not working. So there are multiple reasons to take a critical view of this. But if you are disconnecting a child with learning, if this is happening frequently, you have a problem and you're going to want to pay attention to it. What about this one? The student is off task, insubordinate, and sometimes aggressive after lunch most days, resulting in the student being released early after lunch every day. So what's happening here is that the student is being released early after lunch to avoid the aggressive behavior that happens on most days if the student would stay. So it may not be released early after a violation of code of conduct on each day, but the attendance schedule is set up based on the aggression and insubordinate and off-task behavior that has occurred on most days. This one's a little bit more complicated. I also think it's very, very common. Right? And so this would also be viewed as a disciplinary removal, because what the school has said is that we've got this sort of pattern of off-task, insubordinate, and sometimes aggressive behavior. The student is flaming out after lunch. Maybe they're exhausted, maybe their medication's worn off, whatever it might be. And so we're just going to release the student early to avoid this whole bad situation for them. That is a school's response to violations of a code of conduct. This would be considered a disciplinary removal. And by the way, every day after lunch would be considered a disciplinary removal. So this is going to add up really quick. Right? Before we get too far ahead, there was a question about what if it is written in the student's behavior intervention plan to have the conference? My answer would be the same. If a student is removed because of their behavior and it is a disconnect from their placement or their learning, you need to count it, because it would be incredibly important to know whether that behavior intervention plan is working. So it's not that you can't do it again. It's that you need to pay attention to what this data is telling you. And what we're doing is counting it so that we can collect data about how many times a student is divorced from their learning opportunity, about how many times a student is sent to the office. That data informs the rest of the team about what should happen, because if it's not working, the team needs to respond. So my response is the same. If you look at it as a data collection tool, it doesn't hamstring the school at all. It gives you something to pay attention to. Here's another one. The student is sent home from school after threatening violence with a condition for return, such as a risk assessment or psychological evaluation. So this one I think is clearly a violation of code of conduct, students threatening violence, particularly in this day and age. But how many days do you have to count? You would have to count every day that the student is held out because you've put a condition on their return. All right. We'll gather some questions about behavior intervention plans and removals and answer them as a group at the end. So let's let that one stay there if we can. Does this one make sense, that you would have to count every day that the student is not permitted to return because you're holding them out with a condition? These add up very quickly as well. If you think about that whole graphic again, and hopefully you're able to look at it in the materials, what we're counting, right? In this FAPE-free zone, I've just given you multiple examples of behavior that must be counted. So what exactly is the FAPE-free zone? First of all, you're counting all days, whether they're whole or part, of removal for violations of code of conduct. When you add those up, cumulatively, you have 10 days or less that a student may be removed without providing special education service. And in this FAPE-free zone, it is possible to discipline without regard to disability, right? If a student is removed for more than 10 consecutive days, you are out of the FAPE-free zone because you have a consecutive removal that's longer than 10 days. We're talking here about counting all of those cumulative removals, the short ones, the long ones, all of them. Your responsibilities as a school in the FAPE-free zone include counting. You don't get to stop count until the end of the school year. That count continues to happen with each and every subsequent removal. Second obligation is to be fair, meaning that students with disabilities, even the most irritating students, don't get disciplined more harshly than anyone else. Okay, and your third responsibility is to impose the discipline in the same way that you would for other students, not more harshly, not any quicker, any longer, or anything else. You want to make sure that you're guided by the discipline code of your school or district. Right? This can sometimes be hard because remember, it's counting. The FAPE-free zone starts again with every school year. There are some students who will routinely exceed the FAPE-free zone pretty consistently each school year. Those are students that the district or the school is sometimes inclined to say, we know what's going to happen. Let's just nip this right away. And you can't do that. You cannot impose discipline that's more harsh on students with disabilities because you're going to be vulnerable to a discrimination claim if you do that, right? What about in-school suspensions? In-school suspensions is one of those things that the exceptions consume the rule. So the regulations will start out saying in-school suspension, or ISS, is not counted if, and then it lays out some conditions. If the student is afforded the opportunity to appropriately participate in the general curriculum, right? That means that they have the same opportunity for the general curriculum as they do when they're not in ISS. And by general curriculum, this typically doesn't just mean sending assignments with the student, particularly a student with a disability who may have known difficulties accessing the general curriculum without support. Number 2 here, continues to receive the services specified in the student's IEP. That means that even though a student is in school suspension, if you don't provide all of the IEP services in the student's IEP in the same amount and in the same manner, then you must count the ISS as a removal. And the third one here is continues to participate with non-disabled children to the same extent as the current placement. Okay, that's tough with in-school suspension as well. So if your system is not providing all of these, then you must count it. You can still have in-school suspension. You can still send students with disabilities to in-school suspension. The difference is if you're not providing all 3 of these things, you must count that as a day of removal or a part day of removal, depending on how long the student is there. And in the course of my career, I have seen very few in-school suspension systems that provide all 3 of these to the same extent. So again, not a prohibition, it's a regulation. Just means if you're not doing all 3 of these things every time a student is in ISS, you must count it. Okay. And just for educational purposes, when you see the 71 Federal Register 46715, this is the commentary to the regulations. It's in 71, the volume 71 Federal Register, and then that long number is a page number. So you can always go to If you just typed this in, if you Googled it, you'd get to the right spot. All right, so we're summarizing days of removal here for the FAPE-free zone. It's days of removal plus days of in-school suspension, unless you have provided all 3 opportunities to the same extent. That equals 10 days or less, counting whole and part days, then you're still in the FAPE-free zone. So you got to do a little math in special education discipline, and you keep doing it. You keep counting. Because at some point, if the student is removed for cumulative days, starting on the 11th day, the school has other obligations, right? Beginning on the 11th day in a school year that a student is removed from his or her current placement for any subsequent removals, you have to provide FAPE. That's a given. This isn't if it's a change of placement, it is the student has been disconnected from their education for 10 days in a school year. On the 11th day, you have the obligation to provide FAPE, right? What will be critically different is who gets to decide what constitutes FAPE for the purpose of a disciplinary removal, providing those services, whether it's a change of placement or not. And in order to get that answer, you have to analyze. This is the school that's analyzing, by the way, not the entire IEP team. This is the school. School is typically teachers, principal, dean of students, some disciplinarian, whoever is responsible for these kinds of decisions in your school system, right? So you're going to analyze and provide services, because anything out of the FAPE-free zone, you must provide services, period. You're going to analyze to find out what your next steps are, though. So you're going to look for a pattern. Are the removals totaling more than 10 cumulative school days in a year? Yes, that's why you're here. That's why you're on the 11th day. The behavior is substantially similar to behaviors in previous removals. You have to decide that, right? If a student is repeatedly removed for aggressive behavior, it may be substantially similar, probably is. Right? Another factor you need to analyze is answering the question, because the student's behavior is substantially similar to previous incidents that resulted in a series of removals. Okay. Or because of additional factors like the length of each removal, the total amount of time, and the proximity of the removals to one another. Did something change for the student? Did the educational needs change? Is their behavior intervention plan no longer working? And all of a sudden you've got a series of removals in close proximity to each other. Something changed for the student and it's not working anymore. So you have one of 2 answers here. No, it's not a change of placement, or yes, it is. Those are your only 2 answers, by the way. There's no in between. So the school must quickly analyze and determine whether it's a change of placement. Your responsibilities in the analysis zone, count. You still have to keep counting the whole school year. You keep counting. You be fair and you analyze. And by the way, you are providing services because you're outside of the FAPE-free zone. Who decides what services? That's what this is telling you. So if you're going to the orange zone, which is no change of placement, you've analyzed those factors and you said there's no connection, there's no pattern here. These are just isolated incidents that have totaled more than 10 school days, so we must analyze them. And we're saying it's not a change of placement. The school says that. Look at who decides then. Who determines what educational services must be provided? It's schools and teachers. School and teachers must determine educational services needed to enable a student to continue to participate in the general curriculum, although in another setting. And these are connected by an and, so they both have to be present. Progress toward meeting IEP goals. So the school and teachers get to determine what educational services the student is going to be provided during this period of removal, because this is not a change of placement. This is a de facto, it's a backward looking analysis, right? You're looking for patterns in the removals that have already occurred. And so then you get to the decision-making point of, no, it's not a change of placement, or yes, it is. Just want to point out another and on this slide, and provide as appropriate an FBA, a functional behavioral assessment, and a BIP, behavior intervention plan, that are designed to address the behavior so it does not recur. I want to make sure that everybody understands, if you're going to the orange zone on discipline zones, it's the school that is deciding and determining services that the student needs in order to participate in the general education curriculum and progress toward meeting IEP goals. And then determining if it's appropriate at that point in time, because it's not yet mandated, it is not yet mandated that the student have a functional behavioral assessment and a behavior intervention plan. This is a good place for me to just pause though and talk to you about, we're in the world of discipline here. My presentation today is about the IDEA discipline provisions. There are mandatory trigger points in discipline for conducting functional behavioral assessments and behavior intervention plans, or reviewing them if they've already been conducted. I just want to point out that that is in addition to your overarching responsibility to keep your fingers on the pulse of the student's educational needs. And even if the student never is disciplined, there's never any discipline for a violation of code of conduct, you may have an independent reason to conduct a functional behavioral assessment and develop a behavior intervention plan. And that's because the student's behavior interferes with their learning or the learning of others. So I just want to point out, FBAs and BIPs have mandatory trigger points in discipline, but those are in addition to your overarching responsibility to keep your fingers on the pulse of the student's educational needs. Right. Now, if we went back to the analysis zone, this would be the blue side, right? The blue arrow that comes out the bottom of the analysis zone. And you're determining here that, yes, this is a change of placement. Okay, removals, editorial comment here, just note, removals of more than 10 consecutive days are always a change of placement, always. So the analysis is super easy, super quick. If you have a removal of over 10 consecutive days, you are in the blue zone, in the change of placement zone, automatically, because it's more than 10 consecutive days. However, if the removals are more than 10 cumulative days and you've analyzed them, then you have some obligations here. You've said after your analysis, yes, this is a change of placement. First, you must provide prior written notice and procedural safeguards. Those are mandated triggers, okay? And you must do it quickly because you have determined that this is a change of placement. So it needs to be immediate. That's why you've got to know these regulations before you engage in disciplining students with disabilities. Number two, you determine educational services needed to enable the student. By the way, look who's doing this. It's the IEP team. In the orange zone, it's the school. In the blue zone, it's the IEP team. That means you got to get the team together. Determine educational services as needed to enable the student to continue to participate in the general curriculum, although in another setting, and progress toward meeting IEP goals. So this takes a team to decide this. Not the principal, not the school, not the teacher, a team. And because you said, yes, it's a change of placement, you must conduct a manifestation determination within 10 school days of that removal that resulted in a determination of the change of placement. Not the day you made the decision to say, yeah, that when we look back on it, that's a pattern and it really is a change of placement. We're not talking about 10 days from that day. We're talking about 10 days from the removal, the day that that removal started. So it's 10 school days from that date. You must conduct a manifestation determination. And then still at this point, provide as appropriate an FBA and a BIP that are designed to address the behavior so it does not recur. By the way, they're not yet mandated at this point. It's as appropriate. What that means is that you may have this overarching obligation to say, yeah, we need to know more about the student's behavior. We need to develop a behavior intervention plan because their behavior is interfering with learning. Right? It's not yet mandated in the discipline regulations, but it may be necessary as a function of your overarching responsibility to propose and provide FAPE. Okay. So, did I get through? Let me just double check. Yep, we're good on that one. Some examples here. Change of placement, yes or no? September, the student is insubordinate and uses foul language in class. Gets a 2-day suspension. In November, the student is caught stealing from the cafeteria. By the way, she's hungry. Gets a 5-day suspension for stealing from the school. And then in January, the student uses a school computer to access inappropriate websites and gets another 3-day suspension. So you've got 2 days plus 5 days, that's 7 plus 3 is 10. You are still in the FAPE-free zone. You have not yet crossed into the analysis zone. Is everybody with me on that? You are in the FAPE-free zone because you've got 10 days. You're not over that. So you could discipline this student without regard to disability using the procedure set out for all students, not more harsh, and then you continue to count. If this doesn't make sense to anyone, put a question in the chat because I want to make sure that this is clear to everyone. All right, so same student, the school year continues on. In September, student is insubordinate, uses foul language, 2 days. November, she's caught stealing from the cafeteria, gets 5 days. January, student uses a school computer to access an inappropriate website, 3 days. Now we add on May, the student gets in a scuffle with another student, 5-day suspension. Do the math, 2 plus 5 is 7, plus 3 is 10, plus 5 is 15. We are clearly outside of the FAPE-free zone. We are in the analysis zone because this May removal, this 5-day suspension is what took the student out of the FAPE-free zone and put this student in the analysis zone. So now you're going to analyze these removals. We have insubordination of foul language. We have stealing food. We have accessing inappropriate websites. And then we have a scuffle with another student. Those occur in September, November, January, and May. So really throughout the school year. One might say that these incidents are not substantially similar to each other. They are related in that they're all violations of a code of conduct, but they're not related. For instance, they're not necessarily all aggression, or they're not all anger related issues. They are reflective of poor judgment, with the exception of caught stealing because she's hungry. All right. So some might say that this is not a change of placement because these are not in close proximity to each other and they don't constitute a pattern. So if it's not a change of placement, what direction are you going on discipline zones? Okay, you are going to orange if the team determines this is not a change of placement. And in all likelihood, as I see these discipline cases play out, this would not necessarily be a change of placement. These incidents are not in close proximity. They're not substantially similar. Okay. What about this one? Student loses control in the classroom, tipping desks and throwing papers. There's a 3-day suspension. That's in September. October, student pushes a peer and leaves the building without permission, 3 days. Right? You're still squarely in the FAPE-free zone at this point because it's 6 days. In January, the student brings alcohol to school in her backpack. There's a 5-day suspension. You are outside of the FAPE-free zone here because 3 plus 3 is 6, plus 5 is 11. You are outside of the FAPE-free zone. You are in the analysis zone. By the way, you are providing services to this student. Who determines what services are provided comes from your analysis. All right. So in the analysis zone, you're looking at proximity, September, October, January. You're looking at substantially similar, right? This one I think is a little bit tougher call because you have 2 incidents that are aggression and anger related, and then you have 1 alcohol infraction. When you're analyzing the 5-day suspension that occurred in January, the alcohol infraction, you're talking about whether it was substantially similar to previous incident of misconduct. So alcohol and aggression, I would say that most teams would say at this point in January, there's no pattern. So this is not a change of placement. Who's determining what services need to be provided because it's not a change of placement? It's going to be the school and teachers. But then the school year continues and this student gets in a fight with another girl over her boyfriend and gets suspended for 5 days. So we're at 16. Again, you keep counting the whole school year. We're at 16. We're back in the analysis zone again. And now we've got January, February, September, October, January, February. So we've got proximity now. And we've got 3 incidents that are aggression and anger related. So you might look back and say, yes, this is a pattern. This is a student whose behavior is interfering with her learning because she cannot control her anger. Maybe she's overly impulsive, whatever it might be. So for this student, it would be much more likely to go to the blue zone, which is a change of placement zone. And who in the change of placement zone is determining what services the student gets starting on day 11? It's the IEP team. So you have to have a mechanism for getting that IEP team together now. When is a manifestation determination required? We've done all this analysis. We've said change of placement, no change of placement, and we haven't yet said when the manifestation determination is required. The answer to that is only when a change of placement occurs. So if you go back to our student that we analyzed and it was not a change of placement each time, then there would be no manifestation determination for that student. This is frequently misunderstood by attorneys, advocates, parents, and schools, by the way. If you conduct a manifestation determination when one is not required, you still have to abide by it. So even if you determine that it's a manifestation of the student's disability when you didn't have to conduct it in the first place, you still must abide by that decision. And I'll tell you what that means in a minute. Okay, so within 10 school days of the decision to change the student's placement for disciplinary reasons, you must conduct a manifestation determination. To make this perfectly clear, I'm going to go back a couple of slides. So hang on just a second here. This one. Within 10 school days. Remember we said that it was the 5-day suspension in February that resulted in a change of placement? So it's within 10 school days of that February removal, the day that removal started, that you must conduct the manifestation determination here, because that was the trigger point. It is a change of placement. It was determined to be a change of placement. And it's that removal that resulted in the change of placement. Okay. Here's the flip side of the single page handout I gave you. On one side, it's the discipline zones. And we typically will print that on a half sheet with the discipline zones on one side and this handout on the other side, the manifestation determination. So it's a back-to-back colored handout. We typically print those on thicker paper stock. Sometimes we laminate those because this is a document that should be used over and over and over again in your school systems. So you're free to use it however it works best for you, but know that this manifestation determination page is the corollary to the discipline zones on the front. So within 10 school days of a decision to change placement because of a violation of a code of conduct, the IEP team must review all relevant information in the student's file and information from parents and determine if the conduct in question was caused by or had a direct and substantial relationship to the student's disability, or the conduct in question was the direct result of the LEA's failure to implement the IEP. So I want to just pause there briefly and tell you how this changed when the IDEA was reauthorized in 2004. It is with intent that schools were given more authority, more discretion to handle students' discipline of special education students. So the regulations prior to 2004 The questions were reversed. So the first question was whether the conduct in question, or whether the school failed to implement the student's IEP. And if the answer to that threshold question was yes, then you didn't go on, right? It was absolutely and automatically a manifestation of the student's disability. You didn't have to say that the behavior was caused by this. It was the IEP implemented consistent with the contents of the IEP? If the answer was no, it was a manifestation, right? And then the second question was substantially different. It was a correlation, not a causation. So we didn't have caused by or direct and substantially related to the disability. It was the conduct in question related to the student's disability? So it was a much lower standard, much lower. In 2004, that changed and the standard became higher so that schools would have more opportunity to say, no, it's not a manifestation and we're going to discipline this student, right? Because here's what's happened. If the team says, no, it's not a manifestation of the student's disability, they can discipline the student without regard to disability, but the team has to determine what FAPE is, right? Because you've said it was a change of placement. The student continues to be entitled to FAPE as designed by the team, as reviewed by the team. They still get their annual IEPs. They still get their amended IEPs as needed to meet the student's needs. If it's not a manifestation of the student's disability, you can discipline, but they're still entitled to FAPE. Although in a disciplinary setting, not back in the classroom, not back in their previous placement, okay? Look what happens on the red part. If the answer is yes, the behavior is a manifestation of the student's disability. Now we have the mandatory trigger points for FBAs and BIPs. You must conduct an FBA and implement a behavior intervention plan, unless you've already done so, and not, then your obligation would be to review and or revise. And it's the last one, the third one here, that schools typically push back on, and that is to return the student to the pre-disciplinary placement. So the theory being that we don't punish students for disability-related behavior. We don't punish students for the constellation of symptoms associated with their disability. We educate them. So that student is going to be returned immediately to the pre-disciplinary placement. Right? The disciplinary placement, though, in the event of a challenge, let's say the parents disagree and they say, I know this is a manifestation of my child's disability, but the school says, no, consensus of the team is, no, it's not a manifestation. The disciplinary placement is the stay put placement in the event of a challenge here. The reasons that is true is because, again, the United States Department of Education wanted to afford districts additional authority to maintain safety in schools. Okay, so parent agreement required on the manifestation determination, it's a team decision. So in the same way you make IEP team decisions, it's typically a consensus-driven model. There is no requirement that the parent concur with the outcome. They have the opportunity to dispute it if needed, and it's disputed on an expedited basis. Okay, so yeah, that's typically, if there's a dispute at the manifestation stage, it's because the parents disagreed. How do you conduct the manifestation determination? This is a time to be very thorough and very careful. First of all, gather your team. We're talking about the parent, the LEA, the representatives of the LEA. It would be teachers, it would be administrators, it would be service providers, and then relevant members of the IEP team. What data? You must review all relevant information in the student's file, including the IEP, teacher observations, and input from parents. You're going to answer these two questions. It's the same questions that I showed you on the red and green slide. Conduct in question caused by or a direct and substantial relationship to the child's disability. Or, I'm sorry, I went too fast. Was the conduct in question the direct result of the school's failure to implement the student's IEP? It's a manifestation, or no, it's not. Those are the only two answers, by the way, when you're conducting a manifestation determination, the only two. So no, you're going to discipline, but provide FAPE. Yes, you're going to conduct an FBA, implement a BIP, and return the student. Again, stay put is the disciplinary placement in the world of discipline. It's the only time it's the different placement. In all other aspects of IDEA, stay put is the last agreed upon IEP. That's not true in discipline. Okay, so we're going to apply what you've learned here. Will this manifestation determination review pass the court's muster? Right? An upset student gets physical after a teacher tries to restrain him. Special education supervisor reviewed the student's computerized file, attendance, and disciplinary reports, and some other information. The special education supervisor did this. Based on that review, the supervisor completed portions of the MDR worksheet before the meeting. All right, so there were a few check boxes, and the description of the behavior was already filled out. And then the description of the behavior subject to the disciplinary action was described simply as an assault, and that the student refused a directive. It was noted that the teacher sustained injuries. So it was very succinct, very abbreviated explanation of what actually took place. So at the MDR meeting, the partially completed form was reviewed. The school determined the behavior was not a manifestation of the student's disability because physical aggression is not a symptom of ADHD. So the school indicated that he could identify appropriate and inappropriate behaviors, and the decision then was that it was not a manifestation of his disability. However, a court reviewed this because the parents appealed, and it went through a hearing officer and it went to a court. The record in this case strongly suggests that from the moment the assistant principal who conducted the investigation into the incident received information that a teacher had been assaulted, school administration was determined to have the student expelled, regardless of circumstances. So this is a situation where they were punishing the student without considering all relevant information. And as a result of that, the court considered this a global rubber stamp of what took place. And I want to just, at the risk of running out of time here, I think we'll be fine. I do want to talk to you about the particular circumstances in this case, because it was very telling. And I have the case right here in front of me. The team kept looking at the behavior globally and the disability globally. They didn't look at the constellation of this student's symptoms because ADHD could have broad and varied symptoms for different students. It presents in different ways. So the court took issue with that. This is not a global inquiry. This is a specific, student-specific, student-level inquiry by a whole team of people. Okay, so here's a description of what actually took place in the court's record. The hearing officer elaborated that the record in the case strongly suggests that from the moment the assistant principal who conducted the investigation received information that a teacher was assaulted, the school was determined to expel the student. There was a cursory investigation and a complete disregard of any facts contrary to the conclusion that the student assaulted the teacher. And this, again, was not sufficient. You cannot take a global view in a manifestation determination. They had to take a very specific student level view of what took place. So in actuality, what ended up happening was that the student was roughhousing with his girlfriend, and they were, play roughhousing by all accounts. There's no dispute about that. A teacher in the hall observed part of it, didn't realize that the students were roughhousing, told the student who was disciplined, the special ed student, to take his hands off the girl. He didn't respond right away. And the teacher then grabbed the student. And the student had a strong reaction to that and moved away from the teacher, and in the process twisted his arm, twisted the teacher's arm. Okay. So when he moved away from the teacher, then the teacher's arm was twisted. The school was intent on calling that an assault and was intent on expelling the student for the behavior. In order to be able to do that, they had to make a very specific inquiry into the incident, what precipitated it, how the student responded, what kind of injury resulted, all of those things. And that wasn't done. The school just said, this behavior is so offensive, we can't tolerate it. This student knows better than this. Student knows right from wrong, and it's not a manifestation of ADHD. That's not how you conduct a manifestation determination. Now, on a different set of facts, a careful review of a student assaulting a teacher could very well result in it's not a manifestation of the student's disability. But in this case, they couldn't say that because they fouled up the process. So the court then sided with the parents and the student. Right? Process is important here. Details, details, details. The gravity of a manifestation determination review, meaning a student is out of school or not, warrants a thorough and detailed approach. Here's an 11th grader with an emotional disability, suggests that I laugh because the factual situation here just goes on and on, but he and 4 other students shot up their school with paintball guns, okay? First of all, the student, and the facts in this case are so telling. In this case, we'll deal with whether there has to be consensus reached and things like that. But the facts of this case on page 2, December 16th, the student and some friends met at a restaurant. At the student's suggestion, the boys decided to drive to the high school and shoot at the building with paintball guns. The student had a paintball gun in his car and offered to drive the other 4 boys to the school. On the way, the student made a detour to one of the other boys' cars so that they could pick up yet another paintball gun. All right. So now they have, or actually it was 2 more paintball guns. So they have 3 paintball guns. 5 boys in total then proceeded to the high school in the student's car, and the student's name is Kevin in the federal court case, where they went in Kevin's car where they shot paintballs at windows of the school building and at various vehicles parked on school property, including school buses. At some point during this first visit to the school, one of the paintball guns malfunctioned. So Kevin then drove to retrieve backup supplies, including more CO2 cartridges and paintballs from yet another vehicle belonging to one of the other kids. Kevin and the boys then made a second trip to the school. And at this time, Kevin, who was driving, shot out the window of the vehicle while another boy was steering his vehicle. After the second trip, 2 of the boys had had enough. They decided to leave, asked Kevin to drive them back to their vehicles. He did so and then returned for a 3rd time with the 2 remaining boys to shoot paintballs at the school a 3rd time. All in all, 3 attacks, 30 school windows, 2 school buses, and 1 school delivery truck had been hit with paintballs. So the damage here was substantial. Comes to a manifestation determination. The parents are free to invite other people that they feel are important to this process. The school has an obligation to consider all relevant information and have input from teachers and other relevant members of the team. The school gets to determine who from the school is going to participate in that. So the parents' first objection was that the school didn't pick the right people. That didn't fly with the court. Okay. The second thing is that the school tried to suggest that the parents consented to the determination that it was not a manifestation of the student's disability. Parents said they agreed with part of it, but not other parts. They felt as though his ADHD made him impulsive and susceptible to suggestions from the other students. And the court completely dismantled the parents' argument, saying, impulsive? This went on for a period of hours, resulted in 3 separate trips to the school, retrieving additional supplies, planning, foresight. This was very planned, very intentional, the opposite of impulsive. And then the other thing was that this student, Kevin, was the instigator. There's no way that they can make an argument that his ADHD made him susceptible to the suggestions of the other students. He was the instigator. So in that case, the court upheld the school's decision to say, you don't need consensus. The parents cannot pick the school team members who need to be in attendance. And by the way, this was clearly not related to the student's ADHD, which resulted in impulsivity because this was a very planned, long duration act that the student instigated. So you can see how that one felt very different, and both had very different outcomes in a manifestation determination. So in this case, parents did not invite others, but they objected to the people selected by the school. Court said, no, can't do that. The team considered the student's disability history, his eligibility, educational and cognitive test results. The team also reviewed the disciplinary history and the explicit details of the entire incident. So again, parents made their arguments and the court dismantled each and every one of those. So the ultimate decision was that because the incident lasted over several hours and that there was no impulsivity associated with it, and that he was really the instigator in it, the student simply made a bad decision and now he must live with the consequences. Right? So it was not a manifestation of his disability. That resulted in the school being able to expel him, but they still had to provide services, right? Students with disabilities, even expelled students, receive FAPE. So details, details, details. Let's talk for a few minutes about special circumstances. And I have some good examples in here as well. Schools don't necessarily like these examples, but my job is to bring you accurate information. There are 3 special circumstances with incidents involving weapons, incidents involving serious bodily injury, and incidents involving drugs that can be treated differently by a school. So in order to know if you are in the special circumstances where the school has additional authority, you have to know what a weapon is. Dangerous weapon is a weapon, device, instrument, material, substance, animate or inanimate that is used for or readily capable of causing death or serious bodily injury. Except that such term does not include a pocket knife with a blade of less than 2.5 inches. Why it accepts out a blade of less than 2.5 inches, I have no idea. I don't know, but that's the federal definition of dangerous weapon, right? Now, if you have just a weapon, you might be able to discipline the student, but you can't use the exceptional circumstances unless it's a dangerous weapon. Okay, so school personnel may remove a student to an interim alternative educational setting for not more than 45 school days. 45 school days is a long time, by the way. 45 school days will equate to probably, I would say, 75 to 90 calendar days. Without regard to whether the behavior is determined to be a manifestation of the child's disability. In other words, you get to remove whether the answer is yes or no on the manifestation determination in exceptional circumstances only. And it's if the child carries a weapon to or possesses a weapon at school, on school premises, or at school function, blah, 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 blah. So let's dissect this. If the student carries a weapon and it's defined as a dangerous weapon, that's the only definition we're free to use, or possesses a weapon at school, on school premises, or at school functions. So it could be the state track meet, it could be a football game, it could be any number of places that are considered school premises or at school itself, the school parking lot, things like that. Carries a weapon is much easier. However, there is an inadvertent carrying and I do a lot of work in some states where hunting is a tradition, and a lot of work in the Bureau of Indian Education as well, where hunting is a tradition. And the student has a gun in the gun rack in the back of his vehicle, forgets that it's there, and drives to school. Is that a dangerous weapon? Yes. Did he intend to possess it there? No, but there's no intent in the statute. It's either carries a weapon or possesses a weapon at school. There's no intent associated with this. So could the student be disciplined according to the exceptional circumstances where they're immediately removed without regard to whether it's a manifestation of his disability? Yes, right? Unfortunately, and I've seen this play out over and over again, a student carries a weapon to school, slips it in the backpack of the special ed kid because they won't know any better, and the special ed student gets caught with a weapon at school. Can they be disciplined according to the special circumstances? Technically, yes, but schools must look at each case on a case-by-case basis. And would you really want to in that case? So let's go through some. Are these weapons? A necktie. Principal's necktie, the student used to pull and tighten, choking the principal with his own necktie. Thumbs up or thumbs down? Is that a dangerous weapon? Anyone? I want to make sure I can see. Okay. All right. No, it's not. I'll give you the short answer, and I'll tell you why. Let me see here. The fact that a 6th grade student with Asperger's syndrome, ADHD, and multiple learning disabilities pulled on his principal's necktie when he learned he would not be permitted to leave school early did not allow the district to place the student in an interim alternative educational setting for 45 days. Noting that the student did not carry or possess an object that was readily capable of causing death or serious bodily injury, the hearing officer concluded that the student's conduct did not amount to a weapons offense. You can still discipline this student, but you can't use the special circumstances that get you the additional authority to immediately remove them to an interim alternative educational setting. You must use the regular discipline zones kind of discipline. Scissors. These were dull blades with round tips pointed at another student. Thumbs up or thumbs down? No, not a dangerous weapon. A student with an emotional disturbance pointed a pair of scissors at a classmate in an apparent fit of anger. Although the student used them in a threatening manner, rounded tip scissors were not a weapon for the purpose of IDEA disciplinary removal. The scissors had dull blades and rounded tips and could cut paper only when the blades came together. As such, the judge observed the scissors were not inherently dangerous. Right? So round blade, dull scissors. By the way, this is a kindergartner, so they are actually preschooler, excuse me, is a preschooler. So they are not given weapons to cut paper with in preschool. And so the court said, no, this isn't a weapon. Right? Other kinds of scissors, maybe, but herein is an example of the detail with which you have to review these offenses. Describe the scissors in great detail. They were pointy. They were held in a fist-like manner over a student. I mean, all of that is incredibly relevant when you're analyzing these things, particularly for the special circumstances. How about a paper clip? One with one end straightened, so it was a little pokey thing. What do you think? Thumbs up or thumbs down on a paper clip? Recognizing that a student used a paper clip to cut another student's neck on the school bus? No, it's still not. The judge nonetheless found that the paper clip was not a weapon under the IDEA. The district did not show that the student used the paper clip to cause death or serious bodily injury. Okay, so paper clip was a no. What about a pencil used in a stabbing motion? Again, that additional information is so important. How did the student use what you're suggesting is a dangerous weapon? Okay. In this case, let me find the pencil. A pencil could be, okay, the fact that a student used a pencil to stab a classmate, it could be in certain circumstances, but here, the fact that a student used a pencil to stab a classmate did not qualify it as a weapon. This judge found that the Minnesota School District erred in removing the student. There are other cases where the way in which the pencil was used did constitute a dangerous weapon. We have cases where there have been attempts to stab somebody in the head or the chest. I mean, that could certainly be used in a manner that caused serious bodily injury. But again, it points out the importance of reviewing all of the facts surrounding it as you're making these decisions. Right? A knife 2 inches in length pointed at another student. These are the ones that are so difficult. Okay. Because the blade was less than 2.5 inches when measured from tip to where it met the handle, the judge found that the charter school could remove the student for 45 days. It was 2.5 inches from the tip to where it met the handle. So you even have to pay attention to where you're measuring it, right? It is not 2.5 inches from the end of the handle to the tip of the blade. All of these things become important. Details, details, details. What about drugs? Knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance. So we've got intent here. You have to knowingly possess or use, or you have to sell or solicit the sale of a controlled substance while at school and on school premises. So controlled substance means any scheduled drug. An illegal drug means a controlled substance, but does not include a controlled substance that's legally possessed. So for instance, if I have a Xanax prescription for anxiety, and I'm a 12th grader in school, and I am in possession of my own controlled substance, that is not illegal for me to possess. It may be a violation of school rules, and you could discipline me according to the regular discipline zones, but it is not a special circumstance because it's not illegal for me to possess my own prescription. However, being the good friend that I am, I give some Xanax to my girlfriend who's having a bad day, right? She doesn't have a Xanax prescription. She is now possessing knowingly an illegal drug. She can be disciplined according to the big three. You could remove her to an interim alternative educational setting, but you can't do that for me because I didn't illegally possess it. Unless you change the facts a little bit and I sold her that pill for $5. So when I sell it to her, I am now selling or soliciting the sale, and I am also subject to the removal, immediate removal to an interim alternative educational setting for up to 45 school days. So you see the subtleties and the nuances and how important it is that you have the facts straight, right? Here's the illegal drugs. Again, you have to ferret out the difference between, is it an illegal drug? Is it possessed legally? Is it sold or soliciting the sale? All of those things matter. Who's possessing it? Now let's talk about serious bodily injury, because this is probably one of the most difficult. It means bodily injury, which includes a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss of an impairment or impairment of the function of a bodily member, organ, or mental faculty. You're not free to vary this definition, by the way. You are not free to change it. You can only remove to the interim alternative educational setting if, without regard to whether it's a manifestation, if it results in serious bodily injury, right? At school, on school premises, or school functions. Straight out of the regulations, nothing in the act permits the school to expand this definition. So are these serious bodily injury? A broken nose, headbutting a paraprofessional. So let me go back. A broken nose was, no. Headbutting a paraprofessional resulting in pain, rated at 7 on a 10-point scale. Okay, the teacher experienced redness, swelling, and pain in her arm from the headbutting, and she missed 1 day of work. Okay, so let me say, let me find my place here. Just know that a broken nose in and of itself does not meet the definition. So anytime you get broken nose, you're at a no, unless it caused some other kinds of damage. The next one with the paraprofessional being headbutted, it caused discomfort, disorientation, and a pain of 7. The paraprofessional was given no pain medication at the hospital and was back at work normally the next day. So no, that's not serious bodily injury. It's a bodily injury, but it's not serious bodily injury. You can discipline according to the discipline zones, but you cannot automatically remove to an interim alternative educational setting without regard to whether it's a manifestation or not. Here's a 6-year-old that headbutts a teacher, causing pain, bruising, and contusion. In this case, pain medication was prescribed and the teacher was off work for a week. Okay, so this one could very well, this last one where the student, there's medication, there's extreme pain, and there's lost work, that can be tantamount to serious bodily injury, but you have to analyze all of those factors. Okay, here's another one. The school maintained that a 7-year-old dragged the assistant principal down the hall by her hair, inflicting extreme physical pain, and stabbed a paraprofessional in the eye with a pencil. The problem is they made that up. Okay, the student didn't do that. And when the emergency medical services were called, the student was sitting calmly. And in this case, the parents actually got to go after the school for a federal civil rights claim because they misrepresented and exaggerated what took place. Just a few words about these 45 days removals. The team determines where the student would be removed to, even if you have the authority to do it. And a manifestation is still required within 10 school days because you must do it within 10 school days. The difference here on the interim alternative educational setting, the answer won't matter. You still have the authority to remove the student, but you must do it because it could very well be germane to your assessment of the student's now current educational needs. It's incredibly important information, so you still have to do it. But in the event of the special circumstances, what I call the big three, you can remove the student to an interim alternative educational setting, and you must still conduct the manifestation determination. Without regard to whether the answer is yes or no, you can keep the student in the interim alternative educational setting for up to 45 school days for the big three. But do the manifestation determination. It's mandated anytime you have a change in placement. So in closing here, know the school's authority before you have to use it. Understand the limitations to your authority before you exceed them. Verify implementation at the time of the discipline according to the regulations, and then verify that you have maintained all of the procedural safeguards. Okay, so we only have about 5 minutes left, but now's a good time for questions. So I just want to look quickly at the chat. I don't know, Joanne, did any of those questions jump out at you that should be answered here?
I think there was one or two. Let me look them. One of them wanted to know, someone asked, can you explain a little bit by what it means substantially related to or caused by the disability, just in general? What does that mean?
Yeah, so we know it's more than just related to, because that was how it was before 2004. Since the reauthorization, substantially related means that there has to be a close nexus. But because substantially related or caused by are connected by an or, it could be either one of those. It doesn't have to be strict causation, but it does have to be a substantial relationship. So it wouldn't be a tangential one. It wouldn't be one that is disconnected from, not just a relationship. It's kind of like the difference between bodily injury and serious bodily injury. It's not just a relationship. It has to be a substantial relationship.
Okay,
Right?
there's another question on here. Can school personnel conduct the FBA and BIP, or are certain professionals required to participate?
I would anticipate that the school would have all the personnel it needs to conduct those FBAs and BIPs, but you need to treat them like an assessment. You know, the FBA is an assessment, and OSEP has opined or given us guidance that it does also require consent. So you should, typically schools will have the personnel that they need in teachers that are qualified and credentialed to instruct students with emotional disabilities, cognitive impairments. School psychologists could be involved. So it does not require outside expertise. It does not require, for instance, a particular licensing like a BCBA. So most of the time, unless it's a very small school system, schools have the requisite personnel to conduct those.
Okay, I would like to add to that I often explain this by, it depends on what their data reflects. If their school district is providing the FBA and the BIP and their data does not show the child is improving, they may have to escalate up with someone with special expertise.
Yes,
would you
and
agree
that
with
would,
that?
I completely agree, Joanne, and I would say that that's true for anything, any impact on the student's learning. So that would be true academically. If they don't know how to improve the student's program in order to be able to get progress academically, same thing. You need some more expertise. If you don't know how to change a student's behavior so that you get improved behavioral performance, seek some more expertise. Absolutely. That's your obligation no matter what under IDEA.
Right. We have another question that came early on, and it says, so if their behavior plan has them go to another room where there are fewer students and a special ed teacher, they get 2 reminders and then sent back there, for example, to complete the work, and they come back. So I guess that was in related to a behavior plan. Would that be appropriate?
Right. So, you know, if the behavior plan is part of the IEP, either through, you know, a plan that's incorporated or behavior programming in the form of a goal, you can work that goal. But just keep in mind that if the effect of that is to disconnect a student from their education and they're not getting the rest of their services, or they're not getting, you're creating holes in the general curriculum, then you have something you need to pay attention to. So you do need to look at that. You need to count it. I'm not saying you can't do it. I'm saying keep your fingers on the pulse of it. Because if the only way that the student can get work done is to go to a different location, a different placement, you may need to look at, is this IEP appropriate? Or do we need to look at a different way to meet the student's needs? So I'm not saying you can't do it. I'm saying keep your fingers on the pulse of it. Count how many times this is happening. Look at how much you're creating holes in the general curriculum, because every time the student is sent away from the classroom, they're not getting the same instruction that the other kids are getting. So keep your fingers on it, on the pulse of it, and pay attention to what it's telling you. This is data that you need to collect and pay attention to and count.
Okay, here, there's another question. Here's the scenario. Student has served a cumulative 10 days of suspension. The later incident results in a proposed suspension, resulting in a change of placement. Is it correct that the manifestation determination would need to occur prior to any of the proposed days being served, not an interim placement situation? So if the meeting could not be held within 3 days later, for example, the student would remain in school during those 3 days? Question mark.
Yeah, there's a lot in there. Let me just summarize by saying that if it's the third incident that results in the school analyzing and determining that a change of placement occurred, and let's say that third incident occurred on November 10th, you would have 10 school days from November 10th to conduct that manifestation determination. All right. So you would have to have decisions made at that point, but keep in mind, anytime you're outside of the FAPE-free zone, you're providing FAPE. So you may need to get the team together to be able to say, okay, what if it's a change of placement, then what is FAPE for the student? Because the team has to decide that. So we've got some different timelines going on here. Anything outside of the 10th day, if it's a change of placement, the team has to decide what FAPE is. But then within 10 school days of that incident that resulted in the change of placement, which I've just said occurred on November 10th, you would have to conduct the manifestation determination within those 10 days. The student is out during that period of time.
Okay, we have 2 questions related to manifestation determinations, and I'm just going to summarize them both. Basically, is parent agreement required on the manifestation determination?
So the easy answer to that is no. The team gets to determine that. And if the parent disagrees with the team's decision, they would request an expedited due process hearing pursuant to 300.532. But a parent couldn't stop the team from saying this is not a manifestation of the student's disability. Their recourse is to dispute that in an expedited hearing pursuant to 300.532.
Okay, and one more question. I'm assuming it's related to special circumstances, but it says, how about alcohol?
Alcohol, in my mind, alcohol, unless your state has a different definition of it, that would classify it as a controlled substance. Go back to the definition of drug. It is a controlled substance, a schedule 1, 2, 3, 4, or 5. So in my mind, alcohol would never be one of the exceptional circumstances or special circumstances, unless under the influence of alcohol, the student, stabs somebody with a dangerous weapon and causes serious bodily, it might be a factor that you have to consider, but alcohol in and of itself, at least in my mind, would not rise to the level of a special circumstance because it's not a scheduled drug, which then means that you can discipline the student according to the discipline zones. You just can't use the special circumstances discipline. Right?
That's all of our questions, Lenore, and we really appreciate you spending this time with us. You had a very meaty topic, but I think your PowerPoint and your color options really make it clear to understand. So thank you for being with us, and we appreciate it.
Absolutely, Joanne. Thanks for the invite. I hope I get to do it again someday.
Yeah, me too.
All right. Bye-bye, everyone.
Bye-bye.